is the panel that's going to deal with unconscionability as access to justice, two-way marketplaces, the gig economy, and the international market for dispute resolution services. And the good news is that this is a group that knows each other very well, and so they have decided among themselves how long they're going to speak, and I think it's going to be very interactive. They're going to interrupt each other if they have something to say, which ought to be a lot of fun. So our speakers are Joshua Carton from Queen's University, Amy Schmitz from the University of Missouri, Leonardo de Oliveira from Royal Holloway at the University of London, and Alyssa King from Queen's University. So with that, I will turn over the floor to Joshua, who I think is going to start us off.
Thanks, Catherine, and thanks to those of you attending. As you heard, we've conceived this panel really as a group, and we're going to kind of pass the baton back and forth. Also happy to take any questions from the audience as we go along. So this panel deals with one of those sort of entrenched problems in contract law and in dispute resolution of unequal bargaining power and exploitation by stronger contracting parties. It arises primarily with consumer and employment contracts, but really any time contractual imbalance interacts with the law governing arbitration agreements is our main focus. So the specific problem that we're going to address is arbitration agreements that are designed not to facilitate dispute resolution, but actually to prevent it. An agreement that excludes court jurisdiction, perhaps that waives any right to class action redress, but that also establishes an arbitration procedure that is expensive, inconvenient, one-sided, or maybe all three, is not really a dispute resolution agreement at all. Such clauses can be powerful tools in the hands of a well-advised party which has bargaining power and knows how to use it. In practice, they can be even more effective than an old-fashioned exclusion or limitation of liability clause to insulate a party from liability. But courts in most countries are loath to interfere with arbitration agreements, and for good reasons. In the 160 odd countries that have ratified the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, arguably the most successful commercial law treaty ever, courts are pledged to stay or terminate court proceedings and refer the parties to arbitration whenever they are shown an arbitration agreement governing the dispute that is not kind of obviously facially invalid. There's also the competence principle, which is well known and respected in most jurisdictions around the world. And what it means is that arbitrators not only have the power to rule on their own jurisdiction, competence to rule on their own competence, but also that they should have the first opportunity to consider their jurisdiction, and that courts generally should not interfere until after the arbitration process is complete. Otherwise, if we didn't have the competence principle, there would be many opportunities for gamesmanship by parties and for unwarranted interference by the courts. And what has brought all these issues to sort of new sharpness or new salience is the rise of the online retailers and gig economy marketplaces, right? The Amazons and Ubers of the world. First, they have forcibly transnationalized these issues. So there's the conference theme hook. So that courts in many countries are dealing with the same issues and sometimes even identically worded contracts, but doing so under different statutory regimes and different philosophies of how and how much to protect weaker parties from the consequences of adhesive bargains. More significantly, the online platforms form two-sided markets, bringing together buyers and sellers of goods and services and taking a cut of each transaction. These pose a special challenge for the statutory and common law regimes that evolved before the gig economy was a thing. Consumer protection laws typically cover the buyers, but the position of the sellers in these marketplaces is less clear. Some, like Uber or DoorDash drivers, might have claims that they're employees covered by employment legislation, but this issue is contested and is dealt with unevenly across jurisdictions. Others, like Amazon's third-party sellers, might have concerns around business practices, around antitrust and cartelization, but seldom benefit from any legislative protection. The case that really awakened me to these issues was a Canadian Supreme Court decision handed down last year in Uber Technologies and Heller, which we're going to hear a great deal more about, I think, through everybody's remarks today, as well as similar cases launched against Uber in a variety of other jurisdictions. The court in that case confronted a dispute resolution clause in Uber Eats's contract with its Ontario drivers, which called for mediation and then, if necessary, arbitration in the Netherlands and under the procedural rules of the International Chamber of Commerce. This dispute resolution procedure was inconvenient for Uber Eats drivers like Mr. Heller, the plaintiff in the case, but it was more than merely inconvenient. The filing fees alone would have amounted to more than half of Heller's annual income driving for Uber. The Supreme Court adopted a solution derived from the common law of contracts, that of unconscionability. The majority reasoned that an arbitration agreement that actually prevents arbitration by simultaneously ousting court jurisdiction and mandating an inaccessible arbitration procedure is unconscionable when used by a stronger party to leverage its dominant bargaining position to insulate itself from liability. So the court held that the agreement was void and that Heller could proceed in court. But unconscionability is not the only tool that legislatures and courts can use to deal with the problem of unfair arbitration agreements designed to block access to justice. A concurrence in the Uber and Heller case would have used the doctrine of public policy. The lone dissenter would have allowed the arbitration to proceed, but only if Uber promised to pay Heller's filing fees. There are also legislative approaches, such as those enshrined in employment and consumer protection laws, which have the effect of carving out certain kinds of contractual relationships as simply not being susceptible to binding arbitration agreements. Intersecting with these substantive law approaches, we also see legislative and judicial doctrines to ensure access to class proceedings or that establish institutional processes to resolve specific kinds of claims, such as specialist employment tribunals. So what you're going to hear from myself later on and also from my fellow panelists is the range of different legal approaches that have been taken and that can be taken to this intersecting set of legal, technological, and public policy challenges. To that end, I'm now going to pass the virtual baton to Professor Amy Schmitz, who will contextualize the discussion by describing the US experience with this contract, arbitration, employment, consumer protection nexus. Take it away, Amy.
Thank you. So here we go. Thanks again, Joshua. And this is fun to talk about because there's so much going on here. You have doctrine, policy, law, all sort of converging on this issue. And in fact, how it came to me was I was asked to write a comparative article for the Canadian Journal of Commercial Arbitration, really sort of juxtaposing and looking at how would have this Uber, how would have the Heller case come out under US law, right? What would be the differences? And it brought back some of the research I did many years ago. It was part of a different international arbitration conference in Chicago. And gosh, I guess it was about 15 years ago, so a long time ago. And what I ended up writing about was American exceptionalism when it came to enforcement of pre-dispute arbitration clauses in both consumer and employment, to the extent that under US law, we are under the Federal Arbitration Act and the US Supreme Court jurisprudence sort of glossed over the 1925 FAA. These pre-dispute arbitration clauses in employment and consumer are very enforceable in the US versus that not being true under public policy in many other jurisdictions throughout the world. And so it creates this very interesting way of looking at arbitration as a consumer protection or an employment issue, not really an arbitration issue. So to illustrate that, I'd like you to think about the different layers involved. Right? So the layers involved kind of as a way of scope, kind of like one of these things you're looking through it and there's different layers to the way you would analyze the issue of a pre-dispute arbitration clause, for example, in an Uber contract. On the one hand, you have the Federal Arbitration Act. The Federal Arbitration Act under US law requires the enforcement of pre-dispute arbitration clauses, and the US Supreme Court cases have been very strong in putting a very pro-enforcement gloss on that enforcement. What that means is that if you have a state law, for example, so if, for example, you wanted to say under Missouri law that pre-dispute arbitration clauses in employment, for example, are not enforceable, that would be preempted by the Federal Arbitration Act and by federal law on this issue of arbitration. So it's essentially federalized this question of arbitration that at its heart might be employment or consumer protection related. And it's created a tension. So layer one, Federal Arbitration Act. Layer two becomes contract law, because the one out for enforcement that many courts look to is contract law. Because if you don't have a valid arbitration agreement, then it's a way to say, hey, we're not violating federal law, we're following the Federal Arbitration Act, but this arbitration clause is not enforceable because, for example, it's unconscionable. And unconscionability is one of those ways under US law that you might be able to hold that an arbitration clause is unenforceable. Now, at the same time, we have AT&T, the Concepcion case. And the Concepcion case under US arbitration law says that you are not permitted as a state court to use unconscionability in a way that seems to single out arbitration for special treatment, or to otherwise treat arbitration unfairly, or to look down on it as being a right way for providing access to a remedy. So you have to be careful as a state court. When you are the state court or even a federal court applying state law, you have to be careful in applying unconscionability in a very even-handed way, even when you're dealing with an arbitration clause. So again, lens one equals Federal Arbitration Act, which says enforce arbitration clause. Lens two says contract law, because if you have a contract way of saying that you're not enforcing that arbitration clause, then that's valid. And it just so happens that the most popular one, especially in the Uber cases, especially in Lyft cases, tend to be unconscionability. For example, if you require that employee would have to arbitrate, let's say the employee lives in Missouri, and you require that the only way that they can get a remedy is to arbitrate in New York, well, that's going to be very expensive. And now if you require that the panel of arbitrators is going to be selected by Uber, well, you kind of just created a very unfair forum. That might be a way to say that it would be unconscionable to enforce that arbitration agreement, and that would be permitted even under the Federal Arbitration Act. At the same time, so layer one, FAA, layer two, state contract law, layer three, you have new legislation. And you have legislative carve-outs that have been happening over time. And you've got new bills constantly being introduced in Congress. In fact, there's currently a bill that is focused only on employment arbitration. Now, we've heard a great deal about the FAIR Act, which is aimed at stopping enforcement of pre-dispute arbitration in consumer, employment, and civil rights. Okay, now it has been proposed every year and seems to die on the vine in committee, but there's currently a bill actually being put forth by Chairman Bobby Scott that is got some play in the employment arbitration sphere. In fact, stay tuned. I do a podcast called The Arbitration Conversation, and we are going to be on episode number 100. And episode 100, I'm going to interview Chairman Scott on this new bill that's being introduced. So sort of stay tuned on the state of play under US law. But I think what it shows us, all this is to say, with all these different layers, there's a lot of sort of legal noise in the way that we look at doctrine as kind of these different ways of crafting ways around arbitration where it bothers us, where we think it's unfair. And this really does play very well with this comparative view and going back to the Heller case. Because even in that case, there was this, as Joshua rightly said, there was this kind of, should it have been public policy or is it unconscionability? Do we need to hang our legal hat on sort of this doctrine of unconscionability correctly applied, or is there something else that we ought to be looking at? So all of these different ways of kind of analyzing become somewhat of legal noise in some ways, when in fact we have a public policy issue. With the question being, do we think that we ought to be enforcing these clauses? Why do we think we ought to be enforcing these clauses? Are there reasons why public policy demands that it's not appropriate? Do we have kind of vigilante courts then? Do we have judges that are perhaps finding ways to find a clause unenforceable under the particular facts of this particular case? But does that then create bad law? Because sometimes, and I'm sure many of you have discussed this with your students in class even, where you read an opinion and you think, okay, we have facts where the judge needs to find a way around enforcement of that agreement, but are they now creating bad law in order to get around that agreement? And so I think what it does is set up a really interesting lens for legal and policy analysis. And I'm excited that we're talking about these issues because I think it's worthy of discussion and kind of the different problem-solving tools we have at play, especially if what we really care about is access to justice. And I think that is what we're really worried about for employees, for consumers, especially in a gig economy, considering the sharing economy and what it's created. So with that, I'm going to turn over the legal baton to hear some more voices. Take it away.
All right, I think it's back to me next. And what I'm going to do at this stage is work through the different common law contractual responses to unfair arbitration agreements, some of which we've just heard about, and think about how these might play out and what their prospects are as sort of good candidates to solve these sorts of problems. So the first response is the unconscionability one, which, as you just heard from Amy, is the dominant approach in the United States, at least in front of state courts, and is also, at least since Uber and Heller, now the approved approach in Canada as well. So although the details differ, generally we're talking about two elements when it comes to proving unconscionability, right? Procedural unconscionability, that there was some imbalance in negotiating power between the parties, which the stronger party exploited. And second, substantive unconscionability, that exercise in exploiting bargaining power resulted in a bad deal, right? In terms that are harmful to the interests of the weaker party. Unconscionability has the virtue of being a generally applicable contract law doctrine, available regardless whether there is legislation on point and regardless of the type of contract involved. It also deals directly with the validity of contractual terms, which is the main reason why US courts struggling with the Federal Arbitration Act have reached for it. It's familiar to courts, it's easy for them to administer, and it drives directly at the core issue implicated by purported arbitration agreements that have the purpose and effect of avoiding legal process, which is that they're unfair, right? They're used by stronger parties to insulate themselves from liability by insulating themselves from legal process. But unconscionability also has some serious drawbacks, especially when applied to arbitration agreements. It's seen as conflicting with notions of freedom of contract, especially in the United States, but really everywhere in the common law world. In many civil law jurisdictions, where legislation or regulations exclude binding arbitration agreements for some categories of contracts, general unfairness doctrines can get forgotten in cases where those legislation or regulations don't apply. And this is a particularly salient issue in the case of the online marketplaces, where it's not really clear who is an employee, who's a consumer, what's the relationship between the contracting parties. But more specifically, unconscionability has serious drawbacks for policing arbitration agreements because of the way it interacts with the competence doctrine. If an arbitration agreement is obviously unenforceable, if it is not obviously unenforceable, even if it might look problematic, courts are supposed to get out of the way and allow the arbitrators to decide on their own jurisdiction by ruling on the validity of the arbitration agreement. This is a useful doctrine. I'd say it's a necessary doctrine. Without it, anybody who wanted to wriggle out of an arbitration agreement that they freely signed could do so simply by running to the courts and tying up the dispute in litigation over the arbitrator's jurisdiction. And given the speed that the courts work at, even in developed countries, that can be, not just an effective strategy, but a decisive one. The widespread acceptance of arbitral competence was hard won, given the historical hostility of many courts to arbitration, the ongoing hostility in some jurisdictions. It's not surprising that many people in the arbitration community, especially the commercial arbitration community, have jumped to defend competence from any perceived threat. And this certainly was the response of the Canadian arbitration community to the Uber and Heller decision. I personally don't hold with what Alyssa and I, together with a co-author, called competence absolutism in a blog post we wrote last year on the Uber and Heller case, especially in cases like these online marketplaces, precisely because the line between a commercial dispute and some other kind of dispute is not very clear. And competence was a doctrine developed for business-to-business disputes between relative equals. It kind of wrongly assumes that arbitration clauses were written in order to be used and ignores their possible strategic use by stronger parties. So in Uber and Heller, the majority of the Supreme Court recognized unconscionability as an exception to competence specifically, and that was necessary because otherwise the plaintiff would have had to go to arbitration first, and that was exactly what he claimed was unfair that he was being forced to do, in particular relating to the high filing fees required by the rules chosen in the arbitration clause. So the idea is that a party may go directly to court to claim that it should not be bound by an unconscionable arbitration agreement without having to make that claim to an arbitrator. This has an intuitive appeal, but unconscionability is notoriously unpredictable, right? Inconsistent, even going from judge to judge within the same legal system. And more importantly, for this particular context, deciding on a claim of unconscionability is a contextual and fact-specific matter. Evidence is required not only on the terms of the contract and how these might be unfair, but also of the process of contract formation and whether it involved the exploitation of inequalities. So if a party to an arbitration agreement challenges that agreement as unconscionable, some kind of evidence gathering process, some kind of mini trial may be necessary before the court can rule, whether that's happening in an adversarial or inquisitorial system. So this undermines the entire point of competence, which is to avoid court battles that can grind proceedings to a halt before the arbitration gets going. So for that reason, I prefer another contract law doctrine that might be used, which is voidness for public policy. Right? This is the theory that was invoked by a concurrence in the Uber and Heller case, that access to justice is a core public policy concern of legal systems, which is undermined when parties use arbitration agreements to block access to redress. This has not only been recognized in common law jurisdictions like Canada, but it's also the theory underlying all of the legislative and regulatory carve-outs that exclude binding arbitration in consumer, employment, and some other specific categories of contracts around the world. As applied in individual cases, the public policy principle has the virtue of operating similarly in common law and civil law jurisdictions alike, of relating to the validity of the arbitration clause, which allows you that way out of statutes like the Federal Arbitration Act. Although it has to be acknowledged that the scope of what constitutes public policy also varies a lot from country to country. And so that's a possible source of inconsistencies as well. In particular, Amy can maybe weigh in here, but I think it's difficult to conceive of an American federal court seized of a dispute under the Federal Arbitration Act, finding the arbitration agreement void as contrary to public policy. But I still think public policy has promise as a contract law response to unfair arbitration agreements, more so than unconscionability, partly because I agree with the base principle that access to justice is or should be seen as a core public policy concern, and one that is especially engaged by the way these online marketplaces work. But more importantly, perhaps, a public policy claim can be ruled on by a court based simply on the text of the arbitration agreement and minimal written submissions without the need for one of those mini trials. Another benefit of public policy over unconscionability lies in the doctrine's interactions with the procedures for collective redress. In practice, the kinds of claims that those contracting with the online marketplaces may want to bring can only be vindicated collectively, either because each plaintiff's damages are too small to be economical to bring individually, or also because those same claims are too small to have a deterrent effect on the stronger party when prosecuted individually. While there can be a flurry of individual arbitration claims, as we've seen against Uber in the United States, mostly what we would be talking about here is class procedures of some kind, which now exist in many jurisdictions, common law and civil law alike. So if unconscionability is to be the escape route from unfair arbitration agreements, I find it hard to see how a class could be approved, since class members would have to individually show that their weaker bargaining power was exploited in the contract formation process, and it would be difficult for putative class representatives to show that they share the same harms as the rest of the class. In the Uber and Heller case, the plaintiffs have yet to overcome that particular difficulty. It's now back at the class stage. Okay, so this is presenting the contract law remedies mostly from a common law perspective. And I'm now going to hand things over to Leonardo, who's going to survey some of the other approaches that different jurisdictions have used, especially some doctrines in the civil law.
Thanks, Josh. I just want to share.
We have some slides.
Yeah. Is it sharing or not? Sorry. Now. Can you see? Yes, thank you. Just before I start bombarding you with legislation from Europe, just want to pick up something that Josh said. Correct me if I'm wrong, Josh, you're talking about a blog post that you did with Elisa about competence. Is that correct?
That's right. Last year on the Kluwer arbitration blog.
Yeah, good. I just want to pick up a point because I thought quite interesting that especially something that I will analyze later from civil law jurisdictions, that it feels like, especially people in commercial arbitration, it's like competence is the holy grail, immutable. It's something that you, it's there. It's almost, and then if you compare like the conventions in English law or this view in the US that the Constitution should be interpreted according to the founding fathers, and we can never change that. So it feels sometimes like this, and I agree with you. I think that's a view that is not very flexible, and it was made, like you said, to B2B contracts. It doesn't fit to the reality that we have now. So just wanted to reiterate that I liked it. But now going back, I'm gonna just give a perspective here of some other jurisdictions, and I'm gonna focus a little bit on consumer protection. So there's a lot of legislation that I'm gonna cover here, and that's why I'm using the slides. Starting, I mean, this idea of significant imbalance or déséquilibre significatif, it was adopted in France a lot, but I will show you that this was also adopted in the UK. But it started in 1993 with the EU Council Directive on unfair terms in consumer contracts that establish a contractual term which has not been individually negotiated shall be regarded as unfair if, contrary to the requirement of good faith, it causes significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. Just one observation, this was a directive from 1993. Later on in 1999, there was a regulation, the unfair terms in consumer contract regulations. So might be stated the obvious, directives are not adopted automatically by member states, but regulations are. So that's the difference, but the provision here, the wording was repeated. So I put that this idea of significant imbalance was adopted in France. Not only, of course, the French regulation of consumer code in France has the same provision, not only because of the directive, but also because of the regulation, but they expanded in France, and the civil code also adopted this terminology of significant imbalance, saying in an adhesion contract, any clause which creates a significant imbalance between the rights and obligations of the parties to the contract is deemed unwritten. The assessment of significant imbalance must not concern either the main subject matter of the contract nor the adequacy of the price in relation to the act of performance. Just one disclaimer here, the French code here, the French code, I translated myself, so if there's any mistakes, they're all mine. The German provision that I will mention later on, it's from the official side from the German government, so mistake there. So it's interesting that in France, not only this idea of significant imbalance is adopted in the civil code, but also consumer legislation and commercial legislation. They didn't stop there. Now, I wanted to point out, I mean, I wanted to use more civil law examples, but I thought it was interesting to demonstrate that this concept of significant imbalance was also embraced in English law because of the Consumer Rights Act, and before the Consumer Rights Act, the Unfair Terms in Consumer Contracts Regulation 99. But the interesting thing, if you look at the Consumer Rights Act, section 62.4 says requirement for contract terms and notice to be fair. An unfair term on a consumer contract is not binding on the consumer, and then you have the same language there on number 4, that the term is unfair if it's against good faith and it causes significant imbalance to the parties. So that's straightforward. Interesting thing when you compare to the French case is that the Consumer Rights Act says that the term contracts are binding on the consumer, whereas the French, not the consumer part, but the civil code says that it's non-written. So a different approach. But the interesting thing in this view in the English, in the Consumer Rights Act, is that not only the significant imbalance is more of a EU creation, but you can see that there's a requirement of good faith also, which is not very typical in English contract law. And then I put here the Schedule 2 of the Act provides a non-exhaustive list of unfair terms. And this idea of significant imbalance was put to the test before the Consumer Rights Act, when it was the Unfair Terms in Consumer Contract Regulations. And Lord Bingham at the time explained what it was. It said that the requirement of significant imbalance is met if a term is so weighted in favor of the supplier as to tilt the party's right and obligations under the contract significantly in his favor. This may be by granting the supplier of beneficial option, discretion of power, or by the imposing on the consumer a disadvantaged burden or risk or duty. And finally, I will get to Germany, that the German consumer legislation is actually the Unfair Terms in Consumer Contract Regulations, just like in France. But the German Civil Code, when talking about standard business term, used the test of reasonableness. So as you see on number 1 here of section 307, it says provision in standard business terms are ineffective if, contrary to the requirement of good faith, they are unreasonably disadvantaged. They unreasonably disadvantage the other party to the contract with the user. And then if you move to number 2, it explains a little. An unreasonable disadvantage is, in case of doubt, to be assumed to exist if a provision is not compatible with the essential principles, the statutory provision from which it deviates. Or now number 2, limits essential rights and duties inherent in the nature of the contract to such an extent that the attainment of the purpose of the contract is jeopardized, which is more similar to the, I think, the French approach for standard forms. I just stop sharing now, and I'm just going to try to conclude saying the following. So you have this different approach, which you can see might be similar to unconscionability. I don't think it's exactly the same, but I will give an example how the French interpret that in an arbitration contract. So in the case of KPMG and Madame Lee et Odr, there was Madame Lee had an inheritance, and she hired, her inheritance was in Spain actually, and she hired KPMG and a law firm in Spain that dealt with her inheritance. She eventually didn't like them, and then she went to French courts challenging the contract itself that she had with them, were 2 mandates. And then there was an arbitration clause. Of course, KPMG challenged that. And the French Court of Cassation eventually said, look, you have the directive, which is EU law, and you have French law, the Code of Civil Procedure, which regulates arbitration. But the Code of Civil Procedure cannot overrule the provision that I mentioned in EU law, which is incorporated by the French law. Therefore, they said it doesn't matter that the arbitration was freely signed by her, the agreement was freely signed by her. It causes a significant imbalance in the transaction, being her a consumer, and therefore was not valid. So this is kind of an illustration of how this was done. The German approach, where I put here the reasonableness, I think if we're all familiar with the CISG, we know that this is very German, the way they do that, this test of reasonableness. I don't think it's so strange for English law, not in this context, but the Unfair Contract Terms Act 1977 also has tests of reasonableness. So this is what I wanted to say now to give like a different perspective. Thanks, Josh.
Thank you, Leonardo. I guess, I think Alyssa, you're up next.
Yep. So I'm going to kind of pull us out a little bit. We've been hearing about unfair terms in contracts of arbitration, and the example of Uber versus Heller, as well as Uber's US clauses and problems in the US generally that have come up around consumer and employment arbitration. And then we've talked a little bit about specific legal responses to unfair contract terms in a variety of different jurisdictions in North America and Europe. But I want to go back to why we're here. Like, how did we get here, and why are we stuck and having this debate? And so I want to talk about the role of aggregation and responses to aggregation, and then about competence. So what I mean by why is aggregation why we're here? Well, because in a lot of the cases that we've been discussing, aggregation was the driving factor behind designing this type of arbitration clause. So what do I mean? Well, a lot of different systems have adopted some form of aggregate litigation. There's differences there. There's the US style class action. There is sort of an Austrian style adoption of consumer claims. There's just direct lawsuits by consumer organizations, maybe something to have in Quebec. And there's approaches that are sort of not any of those, but a mass litigation or mass arbitration, right? And those are becoming something of a norm globally. That there will be some form of aggregate litigation, and it's attractive to legislatures to create rights to litigate in consumer and employment cases, because it's a way to do regulation on the cheap, right? If you can have entrepreneurial lawyers or associations aggregate all these claims for you and then go to court to enforce your consumer or employment law, you don't have to do it yourself. Your ministry doesn't have to take on that expense. So that's one of the reasons why it's been attractive in the United States or in the European Union, where there's sort of, very light bureaucracy in Brussels in terms of like actual personnel who can go around enforcing EU law, right? Make it something that people can enforce in the member states, or in the US case, right? Make this, we don't like creating more federal bureaucracy, so let people enforce their own employment rights. And often the way that they do that is through aggregate litigation, because these cases, particularly in the case of employment, like wage cases, those have like high value to the individual, but they're low value compared to the cases that generally get through the courts. And in the case of consumers, right, they might be low value to the consumer as well. These are what we call negative value cases, where there's no point in litigating it yourself because it'll cost you too much money, right? But once they're aggregated, then litigation starts to make sense. Well, as Josh has discussed, right, companies want to avoid aggregation because they're interested in avoiding regulatory litigation. And Josh gave some examples of particularly the gig economy and two-sided markets. I'd throw in social media, right? Anytime where you have a large global market with a couple major players, right? It's very easy to write these clauses and then replicate them. There's a whole line of interesting works in contract scholarship about replication of clauses on the internet and how it becomes really easy to then borrow a clause into a new setting. And so we've seen the replication of what I'll call, sort of for lack of a better term, the US approach to arbitration, right? Where you design an arbitration clause that is going to be very difficult for anybody to enforce against you. And you can see why, if you're a company that's operating across a lot of different jurisdictions, and maybe you're not paying that much attention to those jurisdictions' laws, if you're, say, Uber, right? You want to avoid litigation, and you want everything to, if you have to deal with something, you want it all to go to the same forum that you know how to deal with, rather than being subject to all these different jurisdictions that you're now trying to operate in. And so they write clauses that do kind of two things that make it really hard for people to use them in arbitration. So one is they choose inappropriate institutions, and the second is that they're not prepared to pay. So the first one is the one that Josh was talking about in the case of Uber's choice of the ICC in its driver clauses, right? Choosing an inappropriate institution to litigate the issue of whether somebody is an independent contractor or an employee, right? It's just not the kind of thing that the ICC usually deals with. And their pricing structure tells you, right, that they're usually dealing with higher value business to business cases. The rules are not made for employment arbitration, but this is the clause that Uber uses. I think, I haven't checked everything that recently, but I think everywhere except the US, Canada, and Australia. They're still using that same clause where they're sending drivers to the ICC if there's a dispute. And they're not the only ones. We heard about Lyft, DoorDash, right? Other American companies choosing similar types of clauses. But their rideshare companies outside of the US do it too. Ola is an Indian company, which does seem to vary its arbitration clauses from jurisdiction to jurisdiction, but it doesn't mean that it's choosing appropriate rules. So it wants to send Australian consumers to arbitration in Australia, but under UNCITRAL rules, which are again built for business-to-business arbitration. In the UK, they've chosen the London Center for International Arbitration, right? Again, a set of rules that's not built for this type of case. Or Grab, that's a Singaporean app, ride-sharing app. They use the Singapore Center for International Arbitration rules, right? So again, choosing rules that are built for international business-to-business cases, not domestic consumer or employment cases. And another example, so this is a social media example. There's a case against Tencent now in California state court, where the users are alleging that Tencent locked them out of their accounts and leaks their information to the PRC government, despite them being US citizens using Tencent or using Weibo, which is Tencent's social media app in the United States. The current clause calls for US-based arbitration, but an older generation clause calls for the Hong Kong International Arbitration Center, right? So again, a mismatch in rules, but also the institutional match question is heightened because of the Hong Kong national security law, right? The speech that some of these users engaged in is illegal under Hong Kong law. So even if you move venue outside of Hong Kong, there's questions about how this is going to work, and you're really going to be testing the strength of Hong Kong's laws on arbitrator immunity. So the second issue, right? So if you don't have a clause that's sort of inappropriate because you're choosing a set of rules, a set of institutions, you're sending people to deal with foreign law that's difficult to use in a lower value case, then you have fee issues. So this is what's happened in the United States. There, the clauses are appropriate, and one of the, in some ways, to consumer employment issues. We can debate which institutions are and how much so. But one of the reasons why these clauses make more sense in these sorts of cases is because they have very low fees for the claimant. The defendant pays the fees. So then the problem is that entrepreneurial lawyers have figured out that they can file thousands of identical claims, which is what Amy was alluding to. And this can happen in international arbitration as well. It did happen, not quite at the same scale, with the Abaclat case with bondholders in Argentina. A set of Italian bondholders filed a mass arbitration. So this is that same idea. Okay, we can't file a class arbitration. The clause bans us from doing that. So file a mass arbitration taking advantage of these lower fees. But the problem is the defendant doesn't pay. So what do you do when the arbitration can't go forward because nobody has paid the tribunal. And that brings us then to the problem of competence, right? If we have these clauses that are unusable, either on their face or in practice, right, where fees aren't getting paid, who is going to deal with that problem? And so this is the competence problem pretty much everywhere but the United States, where it's also been called the gateway problem. And as Justice said, right, this is a general principle adopted by most countries that have modernized arbitration statutes, that the arbitral tribunal decides on its own jurisdiction. So the UNCITRAL model law says courts shall refer the parties to arbitration unless it finds that the agreement is null and void, inoperative, or incapable of being performed. And even in non-model law jurisdictions, this is often the language that's used. For example, it's used in the UK, in the UK arbitration statute. So there are three options, right? Null and void, inoperative, incapable of being performed. And you have to fit into one of those. Otherwise, you're going to arbitration. And the problem for claimants is how much the court or tribunal is going to be willing to review this before sending you to arbitration, right? So if it's null and void legally, maybe that's a public policy question. Is it incapable of being performed? That seems to be what's happening with the non-fee payment situations. And it has to be related to the arbitration clause itself. So one of the other principles at work here, again, most jurisdictions have adopted, is that the arbitral tribunal decides on the validity of the contract. The arbitration clause is separable. And so you have to attack the arbitration clause itself. So an unconscionability claim that goes only to the contract as a whole and not specifically to the arbitration clause is not going to be enough. Even in jurisdictions like the United States that don't have a statutory principle of competence, drafters can write it in by using what's called a delegation clause. And then there can be delegation clauses about delegation clauses. And Amy and I can regale you with the US cases about that. But suffice it to say, right, this is going to be a bar not only in model law jurisdictions or other jurisdictions that have adopted that wording, but even in jurisdictions that haven't, because you can do it contractually, and smart drafters or drafters just copying something off the internet from a US gig economy company are going to use it. So you're left with this very little space. There's extreme reluctance to widen that space. Because of the issues that Josh has mentioned, and because courts are going to potentially interpret it differently, right? Public policy on the back end is a little bit more accepted, but on the front end, what are we even doing? And one of the potential downsides to using unconscionability, particularly in this context where we're talking about aggregation, is you have this very, very fine needle to thread, right? So first of all, you've got to hit null and void, inoperative, or incapable of being performed. And then you've got to do it by showing the contract is unconscionable. And it can't just be unconscionable in relation to one party now, which is the typical argument that will get you around problems with federalism in the United States, right? You have to show it's unconscionable for the class, because the context of the drafting of all these clauses is trying to avoid class actions in court. And so that then becomes particularly difficult to do when you have a statute or you have a common law doctrine like unconscionability that focuses specifically on the individual who has signed up for the contract and their specific situation. So that's the the broad overview, if you will, of the conflict, aggregation on one end and attempts to get around it, and then a principle of competence that leaves very little room for challenge.
Thank you, Alyssa. Now we're going to throw it back to Amy, who's going to go into a little bit more detail on the current state of play in the United States.
Thank you. So yeah, this is all really interesting and kind of builds on, we think about competence, which also, of course, in the US has to do with enforcement of delegation clauses. But at the same time, we have these new legal wrinkles that come up in the United States under US law, under the Federal Arbitration Act in particular. And what we're talking about here is Section 1. So the Federal Arbitration Act, Section 1, has this very odd little exclusion, which has now come to be known as the transportation worker exclusion. And it's created a really interesting wrinkle in the gig economy cases because it has come up specifically with Uber and Lyft cases. And again, it all really has to do with the aggregation. So if we want to kind of put things together, and if each of us are building on one another, I think it's a perfect follow-on to Alyssa's conversation about aggregation, because at the heart of the matter, like if you sit down at a table with CEOs who work for these companies, this happened to me once, so I know, and you ask them, why do you want to have an arbitration clause? There's really only one reason. It's because they want to stop class actions. Why? Because they're expensive. It can add, and we can fight about whether or not they're good or bad. I wrote a whole article about what I call the class action conundrum. And in fact, it was in the last Comparative Law Society meeting where I discussed that and had an article on it. So, so we kind of think about this question of aggregation. How do you stop it? Well, interestingly, along comes New Prime versus Oliveira. Now, New Prime v. Oliveira was a somewhat celebrated arbitration case that came to the US Supreme Court and knocked everybody a little bit for a loop. And here's what it was, is in that case, and the reason, which you'll see why it's very relevant to Uber, is because in that case, the argument, right, you had Mr. Oliveira, he was a driver for New Prime, and that was a trucking company, and he wanted to lead a class action of others who were independent contractors who were all working as truck drivers for this company, right? And he wanted to lead a class action with respect to work practices that he felt and the class felt were unfair, as it were. So the case ended up going to the US Supreme Court on a very narrow arbitration issue, which was this. The question was whether or not the Federal Arbitration Act, Section 1 exclusion, which says that all these agreements are enforceable under the Federal Arbitration Act, where you have an arbitration clause, except nothing in this act shall apply to contracts of employment for seamen, railroad workers, and other class of workers engaged in foreign or interstate commerce, quote unquote. The question is, what does that mean, right? So back in the day, in fact, before I started teaching arbitration, we used to think that all employment was under that exception. And in fact, back in the day, in the 1990s and late 80s, there was a thought that, hey, we don't really enforce pre-dispute arbitration in employment because of Section 1. Well, along came some cases, came to the US Supreme Court, and the US Supreme Court said, no, that Section 1 exclusion is very narrow. We're only really talking about, it said, seamen, railroad employers, and other workers engaged in interstate commerce. So what that means are transportation workers. So it's come to be known as the transportation worker exception. So along comes New Prime, and the argument there, New Prime argued, well, wait a minute, these truck drivers, including Mr. Oliveira, they're independent contractors, they're not employees. And therefore, they don't get to use Section 1 exclusion to get out of the arbitration clause. It went up to the US Supreme Court, and the US Supreme Court held, actually it does, because in 1925, they used a very originalist interpretation. And Gorsuch, writing for the court, said, you know what? It says any other class of workers workers in 1925 included independent contractors as well as employees. And so we're not going to limit this to employment contracts. Well, that has huge implications on Uber. How? Well, now we have a split in authority among jurisdictions. And in fact, there are all different cases that keep coming up down the pipeline. I have a whole long PowerPoint on it that, of course, I'm not boring you on. But the bottom line is this: we have different courts in different jurisdictions saying that Uber drivers can fall under this exclusion. So it creates a way for a court to get around enforcement of an arbitration clause other than unconscionability that we've already talked about. So now you have some courts saying, well, wait a minute, the Section 1 exclusion applies, and therefore these Uber drivers do not have to arbitrate their claims, and they can bring a class action, and it's usually what it's really about. And the reason this becomes, again, it goes back to my earlier discussion of sort of cases with bad facts creating bad law, is now you've got courts sort of going very deeply into this question of what includes interstate commerce. So now even that becomes an issue. So you find these really kind of fun opinions. I welcome you to go read them. It's very entertaining. It really is. And with my students, we'll like talk about all the intricacies of it. And it's actually quite fun because they go into specifics. Okay, wait, so it only includes if you're a transportation worker who transports goods, because goods are in the flow of interstate commerce. Does that include anybody who takes an Uber? Well, did they have a suitcase? Suitcase is a good, right? It's movable at the time of contracting. There we go. You know, are they going to the airport? Because now that means it's a person who's in the flow of interstate commerce. They're getting on an airplane, and that airplane goes to other states, right? And so we have really interesting cases where they fight about these issues. In fact, there's a US Court of Appeals for the Seventh Circuit where they do some kind of a very interesting analysis to say that the, I believe it's Lyft or Uber, one of the two, but where they're actually not in interstate commerce, and therefore they do enforce the arbitration clause, versus Ninth Circuit, where you have a case where they're saying, oh no, they are part of this Section 1 exclusion, which brings us all back to the big picture and what Alyssa was discussing in this question of aggregation. Because now we're seeing something else happening on the ground, very practical. Okay, as Alyssa mentioned, there's this question of, okay, wait, what happens if the defendant doesn't even pay the fees to the AAA or whoever, right? How do you go forward with your arbitration if you want to do a mass filing? Well, a couple of things are happening. First of all, this is super hot off the presses, really interesting. Please look it up. CPR, the Conflict Prevention and Resolution, International Center for Conflict Prevention and Resolution, otherwise known as CPR, just issued a mass claims protocol for consumer mass claims, consumer mass arbitrations. They've created a whole protocol around how to deal with this issue of mass arbitration filings for employees. Really interesting, really cool. Check this out. They are creating this whole kind of rubric on the ground because this is a practical problem currently happening because of the way the law is set up. And how do you deal with aggregated with large amounts of individual arbitration filings in these areas, for example, in employment. So now you have this mass claims protocol put out by CPR. Check it out, Google it. Really interesting. I just interviewed Alan Waxman, who is the head of he leads up the CPR, and actually it's really cool. He explained kind of how it works, and that arbitration conversation will be posted very soon. So check that out if you're interested. But on the next level, there's something even more kind of interesting and funky happening on the ground in the real world. And it's this: what we are seeing is companies that are realizing that these mass claims are not actually such a good deal. Right? So you picture them in this kind of two deals on the table, right? And there's this sort of moment. And you're like, okay, we have an arbitration clause because we don't want to be in any kind of a class action. Then along comes people like Travis Lightner. And Travis Lightner, he's a lawyer in Chicago. He had graduated from University of Kansas Law School, really smart guy. And he thought, I'm going to do these mass claims, right? So he's the guy behind Amazon changing their terms and conditions. And this all just happened in the last year. So this, again, is hot off the presses. So what does he do? Well, he and his little sort of consumer law firm, they go ahead and file mass claims. They use technology to help make it very easy That's the other piece that people don't realize is data analytics, technology is making it really easy to do mass filings, okay? So he files hundreds of claims on behalf of individual consumers against Amazon. So now Amazon's got to pay the fees and deal with all of these individual arbitrations. And one thing about the AAA in particular is that they make the companies pay up those fees. So they have a way of sort of dealing with this because they can put you on the bad kid list where they're not going to administer any more of your arbitrations. And so they have kind of an ability to say, Amazon, you're going to have to pay all these fees for all of these individual claims. And lo and behold, suddenly, in fact, it was funny, I'd have students coming to class and like come with their little, hey, just got my new terms and conditions. In fact, many of you who are listening to this or watching have probably received the same change of terms and conditions. Amazon took out the arbitration clause. Why? Because that deal turned out to not be such a great deal for them when they have to pay all of these fees for individual arbitrations. So what we're seeing is companies realizing, gosh, maybe this isn't such a great deal to have these arbitration clauses for these small consumer claims, or same with employment, because then it means that we might end up having to pay and deal with and have lawyers in all these various places dealing with all these individual, we would have been better off in a class action, right? And so now you have this really interesting kind of the tide is turning and companies are changing their terms and conditions and trying to figure out how they're going to deal with these issues. So that's one movement, right? So this is kind of a very interesting turn of events, and you have companies thinking through how they're going to deal with this. At the same time, we of course have this whole world of online dispute resolution. And I happen to be one of the sort of kids that have been involved in this for 20 years, where we're like, you know what, technology is going to change the way we do things. And in fact, it is changing the way we do things, especially in these claims that are kind of ripe for aggregation. Areas where, you know what, there's different ways that we could deal with this that could be cheaper, more efficient, and more effective, perhaps, for expanding access to justice while at the same time keeping company cost low. It's a lot cheaper if you don't have to travel. It's a lot safer in a pandemic if you don't have to travel. So we're seeing a huge growth in online dispute resolution, otherwise known as ODR. And you're seeing companies creating their own ODR systems to deal with complaints. In fact, Amazon has one, and that's how most purchasers deal with their problems with Amazon, right? And so we're seeing this growth of these virtual dispute resolution processes, online processes. And I predict in the future, we're going to see more. Why? Because there's a lot of different ways where we can expand access to justice using technology in a very creative and problem-solving way, while also being acutely aware of the digital divide. We cannot ignore that. We should not ignore that. Now, does that mean we should just give up on access to justice using technology? No, it just means we need to be smart. We need to reimagine the way we deal with these processes. But I think this discussion and discussion of pre-dispute arbitration in employment, in consumer, including Uber, Lyft, the gig economy, I think it really reminds us that at its heart, what we're trying to do is solve this problem of being able to get a remedy in these various areas where it often does not make sense, or it's just not economical for an individual to bring a claim on his or her own. And therefore, we need to come up with a better way. And if we're not going to be able to aggregate, then, hey, why can't we figure out a way to use technology to help us out in this endeavor? So with that, I will turn over the baton.
Thank you very much, Amy. And so we're going to go back to Leonardo now to bring this same kind of update on the current state of play to the global level and some comparisons with other jurisdictions.
Let me share again. Everyone can see it. I'm assuming, yeah, all right. So I'm picking up what Amy said, and we're going to talk about 3 different jurisdictions. I think the Uruguay is the exciting one. The South Africa and the UK is just to show how the approach was different, but it's not as exciting as the Uruguayan case, because what Amy was pointing out, the Uber case in Uruguay was a discussion about access to justice. What happened there is the same thing as the clause that Alisa mentioned earlier, ICC in the Netherlands, the same clause as Uber, right? And you can imagine that the currency, I mean, if it is a little bit an extreme that in Canada, you imagine in a currency in Uruguay, which $15,000 is a lot of the Uruguayan currency to start arbitration. So what it was interesting how they decided in Uruguay is because it's very civil law-like. Of course, that's the purpose that I was saying this. They did a whole Kelsian hierarchy of laws approach to decide that. So they basically stated that, look, you have the generic law, which is providing for arbitration in a code of civil procedure. But then you have the specific law, which is employment law. And employment law has some protections. And therefore, when you have a dispute involving employment law that is submitted to arbitration, the validity of the clause will be analyzed through employment law and not through the code of civil procedure. And then the courts went on to say, well, employment law is directly connected to human rights. You cannot waive all your human rights. Access to justice is a human right. There are limits to how much you can waive. And then the court made an assessment of what type of benefits you would get in the employment tribunal in Uruguay, as opposed to the $15,000 ICC claim in the Netherlands. And the first thing that they established is that there are no court fees to start a claim if you're an employee in Uruguay. So that was kind of the killer there that said, look, you're definitely limiting this person's access to justice, and therefore this clause is not valid. And the court had the right to decide, and the court in Uruguay recognized Uber drivers as workers, because that was the substantive part of the dispute. And then South Africa, that also hit courts, but South Africa is a little bit more interesting in the sense that what was in dispute was the validity of the award. Why? Because South Africa has a system that some employment disputes can be submitted to what is called the Commission of Conciliation, Mediation, and Arbitration. And then it's the same claim. Uber drivers wanted to be recognized as workers. So there was an award issued by the commission, and then there was a challenge to this award, and the award was annulled. Eventually, it was set aside because of a technicality, because there was Uber SA and Uber BV, and the claim was brought against the wrong respondent. So that's why they set aside the award. But it's interesting in the sense that in South Africa, this type of dispute can be submitted to arbitration. Of course, this Commission of Conciliation, Mediation, Arbitration, it's established by law, and it doesn't require the fees that ICC would require. And the odd case is the UK. It's this case that I put here in the first instance in the employment tribunal. And as Elisa pointed out, the same clause with arbitration, the ICC Netherlands, it's present. And I think, sorry, Elisa, you said that it's different. The clause is not ICC Netherlands. You said that it was a different institution. Correct me if I'm wrong. To remember from.
You know, it was at the time ICC Netherlands, but they never made a motion for a stay.
Yeah. So what happened in this case, like you're saying, the parties didn't make a motion for stay, and if you read the case in first instance, the parties accept the jurisdiction of English courts. For some reason, the parties agreed that they didn't want to try to send this to arbitration, and that this case went all the way to the Supreme Court. And then the Supreme Court decided that Uber drivers can be qualified as workers under English law. So after talking a little bit about the Uber case, I'm just going to try to do a comparison here and explain a little bit of how unconscionability works in English law, right? And first started as opposed to this idea of subjective and objective. Here, it's an equitable remedy. And it goes a bunch of years ago, and you have cases that I put here, like such as the Earl of Abbotsford and Morris. So the Earl was about to inherit a lot of money, and then there was a money lender that took advantage of that and charged 60% interest on this loan, and therefore the court thought that was unconscionable. And then in Fry and Lane, it was a little bit about the fact that the person contracted, and that's the language used by the court, was a little from a poor ignorant man at a considerable from poor background, poor and ignorant background, sorry. And it was about property being sold undervalued. And then the court thought, okay, this is unconscionable, we cannot move forward. And then you have later on backhouse and backhouse couple, husband and wife. The husband decided to have an affair, left the wife, and then later on the husband told his solicitors to prepare papers in which the wife that he left was going to assign the rights of their property to him. And he sold this later on at a profit, and the wife went to court, and the wife managed to get a lump sum back of the difference in the house price. And the court understood that was unconscionable because the wife had had been under great emotional strain and had not had legal advice. So that was something very important. And then you move forward to 1985 and the case of Alec Loeb Garage and Total Oil Great Britain. That's a case about exclusive distributorship. Alec Loeb Garages had a, I'm speaking very much English here, petrol stations, a gas station, right? The same thing. Yes, so he had a gas station. And then he accepted a contract that was not very beneficial to him. Later on, he challenged this contract. But the interesting part of this one, that he challenged under unconscionability, and the court in this case understood that it was not applicable merely because one party is stronger than the other, or one party has no realistic alternative to the other proposal, does not render the bargain liable to be set aside in equity. It's interesting in the case of Alec that he had legal advice, but he decided to move forward. So this is a little bit about the evolution of unconscionability in English law. And then I just want to, because I think if I'm talking about this, I cannot disregard Lord Denny's attempt to kind of harmonize the law, right? And Lord Denny tried to create the doctrine of inequality of bargaining power, in which, in the case of Lloyd, Bank, and Bundy, Lord Denny understood that there was a time to unite undue influence, duress, and unconscionability into one doctrine. And then I put a quote here that he said the case, there are cases now in books in which the courts will set aside a contract or transfer of property when the parties have not met on equal terms, when the one is so strong in bargaining power and the other so weak that, as a matter of common fairness, it is not right and the strong should be allowed to push the weak to the wall. So very Lord Denning this, but yes, Lord Denning was unhappy and he became a meme that I put here, that Denning was in the Court of Appeal, and this was the House of Lords at the time, today the Supreme Court, that Lord Scarman said, look, especially very much of English law, if Parliament has not legislated that, we cannot create this. And there's plenty of legislation at the time that regulates this kind of inequality. So this should not be done. Interestingly enough, and this is the case that I put here, the last paragraph, the Pakistan International Airline Corporation Times Travel, this case was decided in August. And this case kind of reinforced this idea. It's a very interesting case. There's a Pakistan Airlines had a contract with Times Travel, in which Times Travel basically it was the sole seller of tickets, airplane tickets to Pakistan. And then what happened was that Pakistan International Airline didn't pay all the claims made by Times Travel, and when they want to renew the contract, they said, you waive the right to claim anything from the past, and we'll give you a new contract. They accepted, and later on, they tried to sue for duress, economic duress. And interesting thing is the first case that the Supreme Court recognized lawful act of duress in English law. And the court talked about the fact that unconscionability was not raised by the lawyers representing Times Travel. And they revised this, everything that I just explained about English law. How do I see, stop sharing, this compare to the other approaches, such as US, as was pointed out, you have substantive unconscionability and procedural unconscionability. Joshua pointed out that this idea of inequality of bargaining power that they want to do is part of procedural unconscionability. Correct? You guys can correct, more than I do about that if I'm wrong. So what I see as a difference here, an interesting one, is that Denning thought that unconscionability was part of inequality of bargaining power, not the other way around, like in procedural unconscionability. It didn't work for Denning, so it's left. I mean, it's a big discussion in English law if this is going to move forward. But just out of curiosity, I would say, if we're looking at consumer contracts, the Uber case, they didn't go through, but if we're looking at consumer contracts, the Schedule 2 that talks about consumer contract, Schedule 2 of the Consumer Rights Act, that talks about the list of terms that are considered unfair. On number 20 says, a term which has the object of or effect of excluding or hindering the consumer's right to take legal action or exercise any other remedy, in particular by requiring the consumer to take disputes exclusive to arbitration not covered by legal provisions. That would be the protection that I would see in English law that consumers have against arbitration clauses in their contracts, similar to that. I find it fascinating that the Uber question is going around the world, and it's really interesting how different courts are deciding that. I don't know. I mean, I think it was a question, but I think Amy had to. I don't know if I'm still around, but it was a question about if this will reach the Supreme Court or not eventually, to see what will be the approach there, and then we might have a parallel in Canada to see the difference. Thanks. Sorry if I lingered a little bit.
Not at all. Thank you, Leonardo. So the next topic before I'll turn it over to Alyssa to conclude, which I think it's sort of now it's a necessity in modern comparative law scholarship, as we saw with the plenary panel this morning, that no comparative study is complete without some consideration of the international or transnational element. And I don't think international law per se, narrowly defined, is very relevant here. But there may be transnational rules, which could be codified in treaties or model laws, or that could arise organically out of legal transplantation or judicial borrowing, or kind of convergent spontaneous evolution of the rules in separate jurisdictions that are all dealing with the same problem, in some cases, in fact, the same contract. But the short answer is no. There isn't much evidence of any of these things happening. There are no ongoing projects at the major rulemaking institutions at the transnational level, like UNCITRAL, the UN Trade Law Commission, UNIDRA, or the Hague Conference on Private International Law, either to establish new instruments or to amend existing instruments like the UNCITRAL Model Law on International Commercial Arbitration. So in fact, the relevant instruments that have been promulgated by these bodies, especially the UNCITRAL Model Law that I just mentioned, they are structured primarily to protect arbitral proceedings from threats from the outside or perceived threats from the outside, primarily interference by courts, who might block arbitration ex ante or annul awards or refuse to enforce them ex post. The model law doesn't even contemplate the possibility that competence might be undermined by an arbitration agreement that is designed to ensure that disputes never actually come before an arbitrator. And there doesn't seem to be any appetite to remedy this blind spot. Perhaps, I don't know, I'm speculating, but my guess is that part of that reason is that the people who make up these commissions are to a large extent arbitration experts. And for the most part, the arbitration community kind of rallies behind any attempt to wall off arbitration from other legislation that might impinge on party autonomy. And similarly, you can see instances of judicial borrowing in the apex courts of various jurisdictions, but there does not seem to be coalescence toward any particular rule in response in substantive contract law or otherwise. There hasn't even been much harmonization of any kind across jurisdictions except for the European Union. Perhaps it's just that the gap between different national legal perspectives is too vast, and each system's dedication to its own perspective too deeply rooted. I'm not sure what the reason is, but we're not seeing the kind of motion toward convergence that we have in other areas. Sort of, we know what it looks like when we've seen it, for example, with respect to the widespread adoption of doctrines that protect competence. We're not seeing any of that kind of movement towards spontaneous convergence in the opposite direction. But I don't think that means we should simply throw up our hands. The problems of unfairness that are generated by the online marketplaces are global problems. They call for a global response, partly to avoid a regulatory race to the bottom, but equally to avoid a patchwork of different rules applying in different jurisdictions that impose additional costs and uncertainties, and that might chill business innovation and expansion. So for that reason, and this kind of pains me to say it as a contract lawyer at heart, the most effective responses might not be in substantive law at all, or even necessarily in procedural law as written in codes of procedure, but instead institutional responses rather than legal ones, strictly defined. So whatever law is applied, an international institution for the resolution of class or mass claims against enterprises that cross borders like the online marketplaces, entrenchment of different ADR processes such as mediation, greater use, as Amy suggested, of low-cost online platforms. All of those would likely do more to address these problems in practice than law reform in any given jurisdiction or even at the transnational level. All right, Alyssa, I'm now going to pass the baton back to you to conclude by wrapping up the core policy considerations that are at stake here.
All right, so yeah, Josh has given us a good overview of why law reform doesn't seem to be enough, particularly where we have definitional debates, right? Whether somebody falls into the category of consumer, whether somebody falls into the category of employee. That's one of the things that makes platform cases and gig cases specifically, it's a subset of platform cases, so difficult to deal with statutorily. And as Josh mentioned, there's also we don't all see the development of a transnational rule, particularly where you want to apply something like public policy as a solution. What we've seen courts do in relation to public policy and the enforcement of arbitral awards is to look for international public policy as a reason not to enforce an award. And one way you could see this being resolved, right, is if courts look for international public policy as a reason to say the agreement is void or inoperative, and therefore the court should be able to decide. But where we don't have the development of a transnational rule, we don't have international public policy. I also bring in an objection to the ODR solution that Amy mentioned and Josh has mentioned. So one danger, I think that this is a solution that can work for a lot of consumer claims. There's some interesting work on in-house ODR processes. One danger of in-house ODR processes is they're never going to get at something that deals with the company's underlying business model. So employment status in gig cases or antitrust in seller cases. Like that's not going to be something that you can resolve through an individual ODR process. But for all the reasons Josh just mentioned, right, we don't see judges acting, and we don't see drafters acting at the international level, the UNCTAD level. So who's going to act instead? I nominate hedge funds. So what do I mean? Litigation funding is already a large industry and is growing in a number of jurisdictions. More and more jurisdictions are changing their attitudes towards litigation funding to allow it in places where it was previously banned. And it is, of course, a staple of international arbitration. So we have a situation in which funders are involved or could be involved in a lot of these cases. There's already rumors of hedge funds, for example, being involved in Brazilian litigation against Uber, and as well in Australian litigation. So if this rule doesn't get sorted out in the public sphere, it will be sorted out by the people with the money. And my guess is that the dispute resolution system that hedge funds devise could look like claim buying, which we see a lot in the investment law context, is probably not going to be designed to accomplish the regulatory goals that a lot of national systems have with legislation around these types of issues. So question whether that the system that will result from inaction is going to be one that reflects goals of class actions or adequately responds to regulatory challenges of the global online marketplace.
All right, well, thank you all for joining us. I guess I'll now pass the baton back to Catherine to moderate questions or pose questions.
Okay, well, thanks, everybody. I thought it was such an interesting discussion. And as someone who teaches contracts, I feel like my learning curve was very steep. So I appreciate all of it. Athena, who has been a very loyal listener to us, has the first question. So I'll ask her to start us off.
Thank you. To my judgment, the first question is if someone thinks here in this topic, thinks that we have an imbalance between the parties or we have not. Some legal orders accept a priori that employer contracts have such an imbalance, and so great imbalance that it's not possible to make a contract based upon free will. Freedom of contract is based upon free will. And the employee has not such a will. He takes the contract, the employer says, open or hiddenly, take it or leave it. The clauses of the contract are already written. The only thing it comes under a bargaining contract upon an individual contract, labor relationship is how the payment will be done, how high the payment will be. They do not come under a bargaining in all these clauses. These clauses come as standardized clauses in great companies, and the employee has to take it or leave it, accept the contract or not. So we cannot talk about a freedom of choice, free will, and contract on that matter, on arbitration clauses. That's why Greek legal order, my order, do not accept a priori any arbitration agreements on labor disputes. German legal order do not accept, in other cases, arbitration clauses, for example, on tenancies upon homes, because we have the same imbalance of bargaining powers. There are so many people looking for a home in Germany. For one apartment come 60 or 80 people begging to take it. So there is such a tension, social tension, that there is no bargaining power. If the contract is given, then the people are very, very happy to have the contract, the tenancy, and they take it, they hire. So in the same case, Civil Procedural Code, in Article 1030 of German Civil Procedural Code, says no, these cases, tenancies, they do not belong to arbitration clauses. People have no bargaining power on that. So we have now discussed so much for common law countries. They have this unconscionability doctrine and other doctrines. The other, Mr. Leonardo said about English law, they do not have unconscionability, they have other doctrines, equitable remedies and all that. Civil law countries are more careful, and they have this mixed nature of arbitration agreements. They say, arbitration agreements. That's a point to the whole discussion, I think, is not only a private contract, is a private contract primarily, has some consequences in the private law, but it's a procedural agreement, has some consequences, Wirkungen, in German law, to the procedural law. So under that double nature theory, both civil procedure codes and civil law codes in the civil countries accept or do not accept under various doctrines the possibility to conclude an arbitration clause. Same thing goes to enforceability. Public policy should or not be shaped common international public policy. That's a big question. I think many legal orders add to this international public policy many notions and things. They belong to their own legal system.
Okay, thanks very much, Athena. I think you've raised some really critical questions. Who wants to tackle that? Leonardo, did you want to take it on, or who wants to? This really goes to the heart of the contract theory.
Maybe I could just say one brief point and then hand it over, which is that, Athena, you've really hit on the distinction between the common law and civil law approaches, which is that the civil law approach here is categorical, right? Certain categories of contractual relationships, you just can't impose arbitration. Whereas the common law approach is more contextual or case by case, right? But both have their blind spots when dealing with these online marketplaces. So the civil law approach, when the contract doesn't or arguably doesn't fit into one of those categories, like are Uber drivers employees, for example, the civil law approach can break down just as much as the common law approach can, but in a different way. Anyway, I think Alyssa and Leonardo both had points to make. I'm sorry if I stole your thunder.
No, sorry, I talked only about civil law countries. I don't know what common law countries.
That's what this conference is for, right? To learn from each other's systems.
So,
Alyssa,
if you want to go
something?
first,
Or,
I don't know. Would you like to go first?
Sure. I was just going to say very quickly, the question where you have a category breakdown, which is the same question that you have when you have a question about whether something is unconscionable, is who decides, right? So a number of the civil law jurisdictions that you mentioned, Athena, are UNCITRAL model law countries, right? So there's very limited space for a court to stay a proceeding, to refuse to stay a proceeding in favor of arbitration where there's a question about what statute applies. Normally it would be the arbitrator who would decide if that statute applies.
I want to ask Athena one thing, if you can confirm to me one thing before I start trying to give you examples of the way I see it. If I remember correctly, and I might be wrong, in German law, employment disputes are not arbitrable, right? Or am I wrong? I think Josh is saying that because I remember that you cannot submit disputes in German law to arbitration, employment disputes.
Yes.
Yeah, that's correct. Okay, so yes,
tenancies, homes,
yeah,
tenancies.
So I remember hearing this, and I was critical to that because what I think you have might be going on a tangent here. I don't know if it will work. It's a clash of principles, right? You have freedom of contract, and you also have access to justice, right? You're free to contract, and also you also should not hinder a person's access to justice at the same time. And you might try to use the arbitration clause to do that. I don't like the extreme, like saying, okay, like the German example, it is all employment disputes cannot be submitted to arbitration. I agree with you that most employment contracts, there's no balance. And I would say to you, the same applies to me. When I joined here, it was a standard form of contract and I had to accept the terms and conditions. I'm actually here teaching people, preaching how outrageous this is, but I also adhere to it. And then I think you have different ways to see that. If you want to take like the economic analysis of the law approach, They say, oh, there might be a give and take. You might accept lower interest, and then you get a clause that's not that beneficial to you. That's one view. But then how far this will go? I don't like the German approach because I've seen this. I think there are different types of employees. You might have the employee that has no bargaining power at all, and you have the top CEO, FTSE 500, that will want an arbitration clause in their contract because they don't want their disputes to be submitted to an employment tribunal because they don't want it to go public for particular reasons, because they might want to work somewhere else, right? And they don't want things to be discussed, or horrible things, like the example that we might have here with a very rich guy named Sir Philip Green, and the non-disclosure agreements of sexual harassment that he allegedly did. So you see, this is the thing. I think it depends. I am not against arbitration, even when there is inequality of bargaining power. I think it can be misused if it is used to curtail someone's right to access to justice. That is problematic. And then I think that is quite clear in the Uber case that Josh talked about in Canada and also in Uruguay. It's, if I remember correct, it was $15,000, and they said that the average Uber driver makes $30,000 in Canada. I think that these were the figures there. That makes no sense at all. So half of your yearly salary is just to get access to justice. Is this a fundamental right? If it is a fundamental right, it costs so much. So you ask yourself this. But I think Elisa pointed out here, the chat talked about the AAA and GEMS protocols, right? Elisa, that they might have a different perspective. And Amy was talking about the Amazon cases, that Amazon was losing a lot of cases under the, I think, AAA arbitration, consumer arbitration, which the costs were reversed. So I think you can have, and I'm just trying to finish here, I'm going to give you a really ludicrous example that I thought a while ago, that because I don't like influencers, but I thought, imagine if you're an influencer, right? And then you have certain image that you sell, but on your private life, you like some toys that to use on your private time, that they are not in line with the speech that you preach. You might want any dispute related to the purchase of such toys to go to arbitration because you want confidentiality, right? And you're still a consumer. Is that wrong? And you might say to me, oh, Leonardo, you're promoting fraud or promoting someone cheating. In a way, yes, but there's still freedom of contract. I don't think, I'm worried about how informed people are and how you can actually guarantee access to justice in the procedure. When it's grotesque like Uber, yes, I agree with you, there's no doubt. But I don't think that all systems are that imbalanced. I think that there might be ways to create balance. And I think Alicia pointed out something about hedge funds, which I found really interesting because I'm not a big fan of that. But yes, I agree with Alicia. And then it can be in different ways. If a hedge fund is interested in doing a mass claim with consumers because there will be a benefit for them and so on and so forth, why not? That's, I mean, I don't know. I talk too much, sorry.
No, absolutely not. Absolutely not. We don't have a lot of time left, but we have time for at least one more question. If anyone has one. Anyone want to jump in? Well, I'll ask a question then. One of the things that you guys didn't talk about that I raise sometimes in my class is the question of being able to challenge arbitration on procedural grounds. And I always point out to them the Jay-Z case, where Jay-Z was able to get his arbitrator removed because he didn't understand he didn't understand the context of Jay-Z's business. Is that a one-off, or is that something that has become more, people have taken that and run with it?
I actually gave a presentation on exactly that issue yesterday at a different conference. The short answer is yes and no. People have not really run with it in the US courts, but that's partly because the American Arbitration Association primarily, which was the arbitral institution involved in that case, but others in the US as well, have diversified their pool of arbitrators. So the issue in that case, there was only ever a 2-week temporary restraining order against the arbitration issued. Because by the time they came back to court 2 weeks later, the AAA had provided a new list of arbitrators with half a dozen viable African-American candidates on it. So I think the issue hasn't arisen partly because the service provider mindset of the arbitral institutions led them to kind of recognize the reality and provide the service that their users were demanding. That's going to happen on the global scale as well. But as Alyssa pointed out, if we don't have some kind of legislative or institutional reforms, it's going to be the third-party funders, right? The hedge funds driving that process and finding institutions who will design for them the kind of process that they want for their business.
Yeah, very interesting. Yeah. Maybe you guys have questions for each other. I don't know. Anybody?
It looked like Alyssa wanted to say something before.
Yeah.
Well, I was wondering if we want to connect, because you were saying there's no transnational rule, and that's in general true. But I was wondering if we want to connect this up to the conversation about business and human rights arbitration principles. So the Hague Business and Human Rights Arbitration Principles include access to aggregation. And they mention class arbitration specifically, and class arbitration bans as something that ought to potentially be unenforceable or unenforced by arbitral institutions. So I'm wondering how this, if this connects to our discussion, and if so, how would we connect it? I would suggest that maybe it's connected because, again, it sort of shows this level of there's going to be reasons to avoid aggregation on the part of certain defendants. And we might want to add defendants now a little bit broader than the ones that we've been talking about. And at the same time, sort of adding to this idea that there's sort of a global push for aggregation. And in human rights cases specifically, aggregation can become the only way you can bring your case, both because people don't want to be individual plaintiffs, and because in order to prove the sort of complex fact scenario, you need multiple people's facts. So you have the same kind of issue where unless you aggregate, the claim doesn't get brought.
That's a really interesting point. I never made the connection because, as Alyssa pointed out, the Hague Principles, they're thinking about aggregation for human rights claims, primarily cross-border tort claims, that kind of thing. But they could, in principle, apply to contractual claims as well, to the extent that those interfere with human rights. I think it's a pretty hard sell to say that a right to aggregation is a general principle of international human rights law.
Oh yeah, no, it's definitely not there. I agree.
But I think that is an example of what you might call the flexibility of capitalism, right? That Marx's big miscalculation was that he didn't realize how much capitalists would be willing to give in order to stay on top of the social order. And this might be an example of that as well, that there's sufficient sort of bottom-up bubbling pressure to deal with these kinds of injustices that we might even see businesses leading the charge to create new procedures or institutions because they were hoping to forestall more heavy-handed regulation by states or by international organizations. I mean, the Hague Principles on Human Rights, they're a lovely document. In terms of legal bindingness, they're a nothing. But they do say something about where the zeitgeist is going, and maybe that's reason to be hopeful.
May I ask something, or are we done?
No, we have a minute.
Okay, I just want to ask, because Josh, you talked about unconscionability not being the best approach, and you talked about public policy. And I want to link something that Elisa talked about, that she mentioned international public policy. That is, I always, when I hear this, I think it's very French because it's in French legislation, right? And also the only two places, the OHADA legislation on arbitration also refers to international public policy. It's part by France. But you have this discussion about, there's internal public policy, international public policy, transnational public policy, and then it goes on. How would that fit into your argument? Because it's a big, I mean, I sometimes feel like the people that advocate this, like Lalive or Bayard and so on and so forth, that this is just national public policy and so on and so forth. Catherine Kessinger also wrote about this, but it's complicated in my view, but I don't know how would that apply in your point.
Oh, that's a good question. I think you can actually sort of avoid that entire problem by talking about it, public policy as a principle of contract law rather than as a principle of arbitration law. And then you can just say, well, it's the public policy of the forum where the court is deciding on the validity of the arbitration agreement. But that would certainly make me a lot more comfortable in dealing with a problem, a social problem that crosses borders, if we're talking about public policy principles that are also shared across borders. My concern there, though, is just that you would have to go to such a low level in order to achieve a lowest, like a common denominator, that it wouldn't actually be very helpful. I don't think you could get agreement on a right to aggregation as a notion of public policy across borders, not in most jurisdictions, not even in all the jurisdictions that have adopted class action proceedings in the last 10 or 20 years. I don't think you could get agreement on that. So national public policy, half a loaf is better than none.
Okay, well, on that almost positive note, we'll call it a day here. Alyssa and I are going to stick around and talk about arbitration in the Soviet Union, but the rest of you are free to move on to the rest of your lives. Thanks very much, and let's give everybody a big hand. It was a really wonderful, wonderful panel. So thanks so much.
Well, I mean, since I had Catherine here, I was just
Yeah.
like, well.
Yeah. No,
I have to go to an exciting graduate studies administrative meeting, so I'm.